So I am going to be very brief. I just want to say welcome to Atlanta's John Marshall Law School. I know most of you, all of you, so there's really not a lot for me to say. I think you know how I feel about our students. I think you all are awesome. I think you are the future that we all need. You know how I feel about the lawyers connected to the Barristers Society. I think these are the people who you need to get where you want to go. It's a collection of people who care deeply about justice. They care about representing people in trial courts where so much harm can be done when lawyers aren't excellent. And it's, to me, just really a privilege that John Marshall is a space where we can bring together students who I think so highly of, lawyers who I think so highly of, and watch the connections form, watch the networking take place, watch the pipeline from law school to practice develop. I'm grateful to the lawyers who have devoted their time. I'm grateful to lawyers who show up to be present and network with you when this is over. And I just want to say thank you to everyone, and I'm going to turn it over to Gary Andrews to do introductions and get this thing rolling.
Thank you, sir. Thank you. Greetings to all in attendance. Excuse me. I am Gary Andrews, an attorney with the Cochran firm, Atlanta. It's my privilege and honor to serve as the moderator for this distinguished panel of attorneys. On behalf of the Barristers Society, Sam Starks, who's one of the founders of it, John Marshall Law School, RAP, we would like to present to you evaluating and litigating premises liability cases. On the panel, I'm excited. We have some great lawyers. We have Sean Williams, a partner with Cochran firm, Atlanta. We have Naveen, Ramachandrappa, partner with Bondurant, Mixson, and Elmore. And we also have Eugene Felton, partner with Seay and Felton. So, everybody should have received a handout and an outline. Let me just give you an overview of what tonight will look like so that we can all be on the same page. We plan to have the panelists speak up to around 7 o'clock. Then we have a meet and greet so everyone can talk and get to know each other. A couple of things we will discuss. You know, this discussion will center around a premises liability case. We'll allow for questions from the audience. One thing I would ask, just identify who you are, student, lawyer, whoever you are. And as I said, we'll have a happy hour. The final thing, and just want to make sure, if you could, please cut your cell phones on silent. I know we're all important. You got these billion-dollar cases, the defense lawyer, someone's going to call and tell you they're going to give you the money, but please, let's make sure we respect that, turn our phones off. So, premises liability. We hear about it, we read about it, and we see it. Premises liability, as some of you know or may not know, is just when your client is injured at a business, an apartment complex, at some establishment. We're governed by OCG 5131, which defines the owner-occupier relationship. So what we're going to do is ask the panelists, how do they evaluate a case when it first comes into their office? So they don't know anything about the case. Their intake is taking the call. So Eugene, when your intake takes the call and someone says they have a premises liability case, what do you think about?
Personally, I think about, because we advertise for such apartments where people have been injured, shootings, murders, and sexual assaults and things of that sort. Just being quite honest, those are the ones that I prefer.
Okay.
And then I get it twisted, and she said it's a slip and fall. I was like, somebody slipped on some water. Ones that I less prefer to take. So when I think about premises, for whatever reason, I tend to think of buildings, apartments, somebody getting hurt by a third party. And I think most of us prefer those cases because, generally speaking, the damages tend to be higher than somebody who slipped on some water.
Understand. Sean, what about you?
Good afternoon. Good evening, everybody. Gary got to say hello, so I felt like I should get to say hello. Well, Gary, the thing I look at is actually no different than any case. I look at a potential client. If you're going to be representing someone in a premise case or any case, and you're going to be devoting your time, resources, you're going to be sharing their pain, their suffering, their hope is going to be put in you. You need to kind of get to know them and see, is this somebody that you're willing to go this fight with?
Now, let me just ask you this. Now, I know we have some lawyers and we have some law students, and so are we looking for negligence? You know, are we? What are we using to standard of care? What are we using?
That's a good point. So when I first say the first thing I'm looking at is this somebody I want to represent?
Okay.
Because you could have a really good case and be a bad person that no one wants to give money to. Also, you can have a really good case and just be somebody that we're not on the same page on how to do that. So that's the first thing.
Okay.
And then you take it in the context of that person you're meeting. You're interviewing them as much as they're interviewing you in the context of whatever the issue of negligence. In a premise case, you need to see how this person fits in their potential relationship and why they was there, what happened while they was there, and the status they have because they was there. Are they invited guests? Did they live there? Was they just staying over their girlfriend's house, wasn't on the lease? All that comes to play, because is he a boyfriend who stayed there, wasn't on the lease, and he's selling drugs? I done went through a whole different scenario before we even got to 51-3-1.
I understand.
So I'm thinking about all of that, because ultimately, as someone's told me, representing someone in litigation is like getting married to them. The best day they're gonna ever be is at the wedding. Everybody smiling, dressed up. If they don't look good to you on day one, day 3 year, it ain't gonna be good for you. So you got to, it's a lot of things you're not gonna know exactly, but if you know in your gut that this don't seem right about the relationship you're about to get into, trust me, and I've had to learn the hard way, that's the first thing I look at. Then I go into those other things.
So then, Naveen, I'm going to come to you, but you all should have gotten a packet, and it should say Carmichael versus CBS. I mean, if you don't have this packet, shame on you. You should have gotten one. It's right up here, as you can come grab one. If you do any premises cases, you're going to always cite this case, look at this case, because it speaks about foreseeability. One of the great things about this panel in the Barrister Society, we have the man who won the case, who did everything regarding Carmichael versus CBS. So Naveen, we're going to give you your shine and ask you to discuss that, and how does it affect the premise liability arena, and what were you thinking about in dealing with this case?
Sure, and I also would like to say hello to everybody. Thank you for coming. And I also want to commend you all for coming in law school, because when I was in law school, I literally didn't know that you could bring a premises liability claim for a third-party criminal act. I had no idea. I didn't learn that until maybe a year after law school, so you guys are well ahead of my own schedule. But in any event, how do I approach cases, and the CBS case in particular? So I primarily do appellate work. So I'm not personally evaluating somebody coming in the door and saying I have a claim. Usually what I'm evaluating is other lawyers. And so, you know, Eugene is talking about, you know, and Sean's talking about like meeting the client. And I'm usually thinking, is this a lawyer I want to go to trial with? Do I trust their abilities to get a verdict? And so when I was approached about the CBS case, you know, one thing that really made a big difference to me in that case was the story of the neighborhood. I was just talking about this, coincidentally enough. This CBS is on Moreland Avenue. It's down the street from Forest Cove. Forest Cove is an apartment complex that if you're from Atlanta at all, you know about. And that part of the story actually made a big difference to me, because oddly, you know, yes, it definitely matters for the jury whether they're going to award money to your client. But sometimes when you get into the appellate courts, it's less about the client. It's really more about the negligence and the evidence in the case and the precedent that you're trying to set. So one of the great things about the CVS case was, notwithstanding some issues with the client, the evidence was just overwhelming. And if we were going to have a case go to the Georgia Supreme Court and decide what the standard is for how we decide these cases, this was the best case, because everybody on that court knows what it's like in that area and knows the rampant crime and knows that it's a partnership between businesses and government that have to be able to prevent this. And so one of the things I was very proud of is that we got a almost unanimous opinion, but also the justice who wrote it was somebody who's from Dalton, Georgia, not an Atlanta person, and yet even he was saying, look, this is a mess and you got to have some accountability. And so to me, that's a lot of times what I'm looking for. Is this a case that I can take to an appellate judge and it'll be sympathetic to them? Not a jury, but to an appellate judge, which is a different animal.
So let me ask you this. Most of the lawyers may know what the CVS case, just boil it down to the law student, just tell what's the significance of this case.
So if we go back to first year torts, there are 4 elements to torts. There's duty, there's breach, there's causation, and damages. So we all sort of understand that, I think, in an ordinary case. And this goes to the question that I had when I was in a first-year law associate, really. How can someone be liable for somebody else's crime? So in the CVS case, our client was shot in the CVS parking lot by a criminal, somebody who was trying to rob him. And so how can CVS be liable for that? Well, the answer to that is that under the statute, under 5131, owners owe a duty to keep their invitees safe. And so the question in the CVS case is, okay, well, when does a criminal act become part of the owner's liability, and when is it something that's totally unforeseeable, it's called an intervening cause, so that it breaks that causation element or breaks their duty? And so what the CVS case said and the Georgia Supreme Court said is the question of foreseeability goes to duty. So it's part of the duty element. Didn't have to be that way. In fact, I argued it should have been proximate cause. But anyway, they put it in the duty element, which is fine. And then the question is, if it is foreseeable, if it's something that a landowner could foresee, then they have to take steps. So if you've got a lot of prior crime, or you've got employees that are saying that this property is unsafe, then that needs to be part of the duty. Yeah.
How did you prove the prior crime? Did you have to prove it then?
Just give us 1 second and we're going to come to that. I promise you that question will be answered.
Yeah, so that's going to be a huge part of the practical aspects of it, but I'll just sort of real quick.
You're thinking right, though.
Yeah, exactly, right. Well, and this was the big issue in the CVS case. What it all boiled down to is, can you only prove a premises liability if there's prior crime, or can you consider other types of evidence? For example, if everybody in the neighborhood knows that this is an unsafe CVS, is that enough? And so that was sort of one of the big issues in holdings of CVS, which is why for decades probably, people will be citing this case because it tells you what type of evidence that you can rely on, and I think we're going to talk more about that.
Yes.
Gary, can I, from a practical standpoint, say something?
Yes, sir.
We do duty breach, proximate cause damages is the tort on what a claim is. The thing that's unique about premise cases is there is no duty but for a statute. Most times we got reasonable person. Most times is what a reasonable person would do. Or we have, like we do in auto cases, a stop sign or red light. The statutory duty is what creates this, but it's important though. In premise cases, in regular cases, just duty and breach. The reason you gotta have that duty in the statute is not created unless it's foreseeable. Now I know you argued against that, but that's what the court said. You don't have a duty as a property owner to do anything regarding providing a security until it's foreseeable that some type of crime would happen. So property owners typically don't have to do anything but just be reasonable. So I'm gonna pause
you right there. So now we got them hooked in. So now we know we got foreseeability. You talked about the marriage. Do you want to be engaged or married to this client? So Eugene, they sign your contract. What are you doing next?
This is a great segue. Any premise case, first element you got to prove. And Sean hit the nail on the head with regard to the owners, and there's some actually law that says he doesn't guarantee your safety. The first issue is, can I show notice? Can I show that the owner, if you're dealing with slip and falls, knew that the water was on the floor so he could take steps to get the water off before somebody else? It's called superior knowledge. Did he have notice? In the context of a crime or an apartment, you have to show that the owner, the occupier, had noticed that the criminal activity on his property or immediately around his property presented a danger for the invitees, the people who were coming on. So you do that by a host of ways, by showing that somebody had been shot on the property before, they had complaints about people coming in and shooting other people or firing guns on the property, those kinds of things. And we had gotten off into this very calculus of it almost had to be identical, substantial similarity, and that's where we kind of
That's where he helped us out.
That's right.
So Sean, the case come in, what are you gonna have your paralegal do first?
Well, the first thing, we're going to be sending out letters of preservation to the property owner and the builder owner or the occupier to preserve all evidence.
Why is that important?
Because things change. They could fix something. They could change the light bulb that wasn't working there. That video surveillance camera that shows what happened could be gone. The leasing property, the contracts with security people, all of that stuff you need to try to preserve. The next part of that is you want to make sure you go out and get prior crimes on the property. You want to see what was the property owner or the occupier on notice with. You can send out open records requests to the local law enforcement and get criminal activity, not only at the premise, but in light of CBS, everywhere in that area, so that you can set the story that this is not just a bad crime area regarding the occupier, but they were on notice that the whole area was. Because the more notice you got, i.e. foreseeability, it's interchangeably, the more duty you can spread out on.
So let me pause you right there. Naveen, did you have that in mind when you were arguing the CBS case? Did you have Sean Williams thought in mind?
I did. So when I argued the CBS case, there was actually another case that we were also arguing, which was Welch versus Pappas. So in the Welch case, a couple, the husband was shot to death in the parking lot. And I only took that case at the Supreme Court level. The prior lawyers had lost it in the Court of Appeals. And the Court of Appeals said, no, it's not foreseeable because there was no prior shooting in that parking lot, which is true. There was no prior shooting in that parking lot. And what we did, and what I was arguing up there, was I was combining two things. There was a shooting down the street, and down the street was a little bit of an ambiguous term. It was Windy Hill, so how far, we don't know. It's for a jury to decide, not for a Court of Appeals to decide. So anyway, so we had shooting down the street, but in the parking lot, I went through all the evidence in the record. There were a lot of thefts of guns in the parking lot. So people were stealing people's guns from the cars. And so the combination of those two things made it foreseeable, or at least a jury could find, that someone would be shot. Because the fact pattern in that case was that the assailant was going to rob this person's car, ran into them, and then there was a sort of escalation and guns and shots were fired. Well, if someone's stealing guns from a car and there was a shooting just down the street, that's the kind of notice that you have. So yeah, I was definitely, as I was arguing that case, I was like, we're not gonna just be stuck at this property because that makes no sense. Nobody looks at, they don't even know, nobody knows what the property lines are.
Right.
It's just a question of, is that area dangerous and should they be taking protections?
So Eugene, you've been doing this for 25 years and you want, there's normally a shooter involved, so you're gonna get the criminal investigation filed, correct?
Correct.
But we always get the pushback from the DA saying it's an open investigation, correct?
That's right.
And so what do we do?
Well, you do everything you can because you never know how long a criminal case is going to take. So sometimes the things that are in the criminal case may not be available to you for 2 or 3 years, and most certainly as plaintiff's lawyers, we can't wait around for 2 or 3 years, so we do the next best thing. We go and find other things that are available in the area that we can use to put the defendant on notice of criminal activity. I had a case recently that I thought was excellent because the security officers were complaining about their security guards getting beat up by gang members. So if the security guards are complaining about too much crime and not having enough security, and they were reporting that to the owner, and we use that to say, hey, you needed to have more security. So the number one thing I think, regardless if you can get the DA's file or not, and a lot of times we have an exemption to Open Records Act. If a pending criminal case is going on, the DA doesn't have to give you that file.
Shean, you dealt with that issue, and what's and this is the Barrister Society, we're learning, so it's not one particular way to do anything. Shean, what's your way of trying to get the criminal investigation file?
Well, I hope that I've given the DA enough money in the election that I didn't have this problem.
Okay.
But last DA, I supported loss, and we're now dealing with some other stuff regarding phone calls and stuff. So, but really, you got a couple options. There's now some exceptions under the Open Records Act you can kind of argue. As being a victim or a plaintiff, I think there's some exceptions you can kind of get around. They still kind of buck off on that. The other thing, you can just file suit and serve a subpoena and ask the court, the DA, to come down to your office and bring the documents, and next thing you know, everybody's sitting there like, whoa, and we can kind of come together on an agreement to say, you don't have to come down here and answer the subpoena, or they'll file a motion to quash, and you get the court involved, and you say to the judge, look, Your Honor, we respect the criminal process, but we can't wait forever on this. My client is prejudiced every day. We are not able to start investigating this case, finding out who witnesses are, finding out what the police found at the scene. And so the judges are typically saying, you know what, let's balance this out. There's certain things we're going to let you get, certain things you're not. As long as we have a good confidentiality order in place, we typically can get it regardless of kind of that. I will say this, because I think we kind of, as part of the investigation, y'all look young, or maybe I'm just old, but y'all know Perry Mason?
Yeah.
Okay, y'all may be.
There was a reboot too, so it's come back.
Oh yeah, it is. He always had the best investigator.
That's right.
Really, to be honest with you, you gotta have a really good investigator or somebody that you hire to go out and start getting evidence that you can't wait on the police to get. And you can first start with the family you're representing. They know what happened. They know some people in the streets, and on the streets they saying. You can start getting that started with an investigator or anything like that. Get witness statements. You can also go start to talk to some people like former employees if you can find them. We usually don't get that information until we get into litigation, but as much information as you can get, the why and kind of the whole structure of kind of like Forest Cove, I've sued them multiple times. At some point, there's somebody out there too, some other plaintiff's lawyer, there's somebody who sued them. You can get as much information beyond the criminal file that the DA is holding it up.
So Naveen, we're going to move off of this, but let me ask you this. When you're looking at foreseeability, what did you appreciate that the lawyers had for you to be able to show foreseeability?
Well, one thing that was mentioned that I think is really important that we'd be very clear about, it's not just that there's prior crime, it's prior crime that the defendant has notice of. And that can be tricky because you've got some defendants that are just putting their heads in the sand and ignoring things, but you've got to tie everything together. So for example, you do all your open records requests, you get all these crime reports, and there's just, you feel like you're great. But you've got to be able to tie that to the defendant, that they actually knew that those crimes were happening. So sometimes that means reading the police report and seeing the part where the police officer speaks to somebody and puts it in the notes. It may mean going to interview some of these witnesses. I mean, in my ideal world, and you guys will hate me for saying this, but I'm going to say it anyway, I would love it, and I love trials where the victims of the crimes, of those prior crimes, actually comes and testifies. Number one, I think it's the most powerful evidence that you'll get on foreseeability, to actually hear it not to just read a police report, but to hear the victim say, this happened to me, I told them, and they didn't do anything. And they had that in the CBS case, in the Carmichael case.
Okay.
And so when I was looking at the weight of that evidence and seeing like what would be persuasive for foreseeability, not just for the jury, but also from the appellate courts, it was a little bit easier because they had prior employees who had been victims of armed robberies. But having like somebody who worked there, who was from the neighborhood, say, they put a gun to my head and I told them, you got to get an armed guard, and they didn't do anything, that's the entire case. And even as an appellate lawyer, somebody who likes to talk about statute numbers, I was even, moved by that.
When you say notice, are you talking actual notice? Where my mind is going is how far do you have to go to tie that notice? Is it the employees? Is it, because you can't account for their reporting system, whether or not that owner, maybe it's just a franchisee, the manager, the corporation. You're trying to sue everybody for everything.
Right.
You can, right? How far do you have to prove that notice?
Yes, it was a really important question, and one that I deal with frequently. So I try to divide it up into two different concepts. So there's a concept called actual notice versus constructive notice. And so actual notice is like what you actually know. Constructive would be something that we say you should have known. But then there's a separate concept about imputed notice, and I think what your question is going to is imputed notice. So if one of your employees knows, does that, for example, so the CVS employee was actually subject to an armed robbery. Is that imputed all the way up to the top of CVS? It goes throughout. And the answer is usually yes. And the reason it usually yes is because the knowledge that an employee has goes to the corporation when it's within the scope of their duties. And I see this from good plaintiffs attorneys. They will ask the employees in a deposition, it was part of your job. If you saw some criminal act, it was your duty to report it, correct? And most people say yes. And there's a phrase that one of my favorite lawyers, Gil Deitch, uses, eyes and ears. You're the eyes and ears of the company. And if you get that kind of testimony, then you don't need to have management level. It's just the employee, because that's part of their job. And whether they report it or not, even the fact that they didn't report it, that's still imputed under that concept.
And to follow up on that, in the categories of actual and constructive, actual is you got an incident report from a security guard that works at the complex or the CVS that send an internal incident report monthly or weekly, and it goes up the chain. That's obviously the easy thing, or some emails. So you ask for all emails. You ask for all notices that go out to leasing apartments lease. They send out to their tenants notices of crime that may have occurred. So those are all actual. The constructive stuff is kind of like what Naveen was saying. Like, I go through a police report and says, okay, look at what's the telephone number of the leasing office, and then I look at every telephone call that was made, and if any calls were made from that leasing office about a crime, that's notice as well. You got times in the day, if an incident happened on a police report during the middle of the day, and the leasing office is from 9 to 5. No one may have done it, but I ask in the deposition, so your leasing office is open from 9 to 5. And if someone was, they have to drive on, if the police came to this scene of this apartment complex, they roll right past you. That's constructive notice as well. And then the imputed stuff is, get a bunch of former employees. Every time I do discovery, I'm like, I want everybody who worked there the last 5 years.
And we'll get to that.
Somebody ain't happy.
Yeah, so Eugene, we're still in pre-suit, so we're getting ready to file a suit. What are you doing about insurance and what, because we can't just sue somebody who doesn't have any money, correct?
That's right. And one of the things, as Sean mentioned when he was talking about the spoliation letter, which is basically preserve things, you also send out a letter to make sure, in Georgia, unlike a lot of states, we're blessed in that before you file suit, you can request whether or not the defendants have insurance, and that they tell you, and that they put their insurance carrier on notice, and they give you a proof of insurance. And so that's one of the important things that you want to do. And why is that important? Because as it relates to nightclubs and things of that sort, I can't tell you, it's a toss-up as to whether certain business establishments have insurance at all, right? Especially nightclubs. And what you will want to find out is, you will find that out before you file suit, because it could be quite expensive to get in litigation, then find out later on there's no money there. Yeah.
So Sean, now we know there's money, how are we gonna know who the owners are?
Well, you don't always know it's money.
Well, we hope there's money.
We hope there's money.
So how are you finding, so nightclub, like Eugene says, there's gonna be the parking lot layers. How are you finding out all the owners involved in a particular premises case?
Well, I'm smart enough to realize I can't figure that out by myself, so I hired somebody whose responsibility and job is to go do searches on deeds and really get somebody who's doing title searches. Make sure you got the right people.
What's the importance of that?
Because you'll file suit against somebody just because they look like they own it and they don't actually own the property. And the owner is an occupier under Georgia law. The management company could be considered an occupier. So you need to find out, just because someone says is, I don't know, Forest Cove Apartments, and the management company is, that don't mean they own the property. So you need to make sure you exactly know who owns it. The biggest thing you see in this is kind of like gas station cases, which are not always the best, but the guy who's running the gas station, he don't own anything. He don't own the gas, he don't own the pump, he don't own the land, he don't even own the cookies in there. But you're dealing with that person, and by the time you sue everybody, if you didn't figure out who actually owned the property, who probably got it subleased from somebody else, you're gonna find yourself in a different situation. So find out who owns the property, and then the relationships between everybody else.
All right, so now we've done our pre-suit. We know who owns the property. We know who whether or not they have insurance. There's different styles of claims that we could bring on a premises case. So we deal with apartment shootings, but it's also slip and falls. Eugene, do you handle slip and falls, or?
I'm going to mediation Monday on one against PF Chain. Yes, I do.
Why? Why are you?
$400,000 of medical bills. That makes a difference. But it's the same issue in regards to those kinds of cases. You have to, as Sean said, starting out, you want to preserve the camera. And in our case, a lady had fallen on some water. There was a failure to put up any signage, and she fell, injured her back, and had surgery. So with regard to those kinds of cases, a slip and fall, you want to know, do they have procedures in place that the Court of Appeals call reasonable inspection? How often do you inspect the floor to make sure that there's no water in place? If you fail to have reasonable inspection procedures, that's important, because that allows you to beat summary judgment. And when you have a case with hundreds of thousands of dollars in medical bills, and you know you're going to try the case in DeKalb County, then that makes a difference.
So Naveen, do you handle slip and fall? So we know you for the CBS case, but I don't want to pigeonhole you in.
No, I do. In fact,
case.
what I was flipping through is one of the handouts has expert witness cases, and there's a case, City of Suwanee versus Padgett, which is a case that I handled on appeal, and the defense of the trip and fall case that I will make, and I will use specifically the Padgett case. This was a grandmother who tripped and fell when she was going out for a walk in this, like, one of these rails to trails path out in Suwanee, and it was absurd. I mean, it was one of those things where your vision is focused on not getting hit by a car turning, and there's a giant root that is built up the sidewalk, and there was an arborist who said, yeah, I told them 10 years ago this is a major problem. They just did nothing to fix it. And if you've had anyone, and I have this experience myself, who's had some kind of fall where they've lost mobility, the loss of autonomy and the isolation that it causes a person is profound. And I'm just as happy to represent somebody in that situation, someone who's been shot. I mean, it's not the same, but don't get me wrong, it's just as serious.
So we have slip and fall. We have, Yes,
Jerry,
sir.
about 7 years ago, there's another type of case, and 51.3-1 can be very, very broad. About 7 years ago, we had a case where a slumlord had owned a property, and it was actually a trailer, and he had a tree up, and somebody had reported that the tree needed to be cut down because the squirrels could run through the tree, which means it was very hollow. And the next door neighbor was cutting their trees down, and the tree people had come over and said, "Hey man, you need to cut this tree down. We charged $1,000, but it is so dangerous. We'll do it for $600 because somebody's gonna get hurt." And the owner wanted to do it for $400, and he didn't cut it down. Literally 2 weeks later, the tree fell and killed a baby, right? Fell, and the tree fell on the trailer. They called the firemen out, and the little trailer didn't collapse until they tried to cut the tree off of it, and it just smashed the baby and it killed the baby. And he actually had like $200,000 worth of insurance. It was a pre-suit. But going back to premise 51-3-1, owner occupier of the land, defective tree on the property. He knew it was defective, and everybody in the neighborhood knew because squirrels were running through the hollow tree, and he had been placed on notice. First thing we did, because he actually owned a lot of real estate, and we were able to get the people to say, yeah, we told him he needed to cut it. So it was a clear case. The only problem was there's not, of course, sad case of the baby, but there was no insurance, but very little insurance, $200,000.
So we can always use negligence in these type of cases. Is that fair to say?
Yeah, as long as you can prove notice.
All right. So now we're building up. Client, the marriage has been consummated. We've got our facts. So now it's time to file the complaint. So as we file the complaint, we have some lawyers out here. We have some law students. What theories what theories of recoveries are we going to try to seek in a premises liability complaint? And let's just say apartment shooting.
Yes.
Yes, sir. Let's ask you, Mr. Williams.
Can I go back a second and answer this question?
Sure. In 35 seconds.
I don't know if I can do that, but I want to make sure we don't miss an important factor when I was talking about getting to know your client and their status. Because all of these responsibilities we're talking about really depends on what type of person this is. Are they an invited guest? That means, are they a customer? Were they a visitor of someone who had a legal right to use the property? Are they a licensee? Or are they a trespasser? Those changes the duties that the property owner will have based upon how you classify that person. So when I was saying the first thing I want to know is get to know the client, because I need to know what category you fit in, because it changes my theories of liability.
Can you pause for 1 second, Mr. Stars?
Yeah, on that note, Sean, Eugene, Naveen, can you guys, and I meant to say this earlier, tell for the students in here, can you talk about premises work from the standpoint of just access to justice and marginalized communities, and what sort of things you see as it relates to who the clients are and the sort of things that are happening to them?
I will. And then I'm going to let Naveen talk about the distinction and the importance of the distinction of the status. So, getting back to this marriage, I'm trying not to make it too simple, but the reality of it is, when they come in your office, you are typically looking at people who are staying in places that they don't have financial means to stay in the best places, the best security. They're not going to have where the trees and arbors came out to cut things down. They're going to find themselves in gas stations where they're stopping to get gas in locations that are in bad neighborhoods, right? And so they're not going to appreciate what typically comes in our office are people who, well, maybe I'm staying with a cousin because I've been out homeless, but I'm not on the lease. So does that change who you are? Do you not have the same duties and responsibilities? Because when a defense lawyer gets that file, they're looking at you not as a human, they're looking at you as a case, and where do you fit in the status? Because they don't care that you've been staying there a month, and maybe you're not on the lease. They're gonna argue you're a trespasser or a licensee. And that changes the duties and responsibilities. And so when we take these cases on, where it's a negligent security case, where it's a case of dealing with a baby, all of those things come in play. And I give you an example, of a theory before Naveen talks about the status. Sam and I had a case in Ohio. You may have heard about it on the news. Well, a young man is walking into Walmart, and I'm over my 35-second limit with Gary, but I'm okay. He walks into Walmart with a friend of his. I say a friend of his. It is the holiday, so they're going in there to get some things for Walmart to go meet some friends for like a cookout. They're walking around, his girlfriend calls, not his friend that he's with. He tries to ignore it, and the other young lady says, you need to take that. So he decides to walk away while he talks to his girlfriend, who probably doesn't know where he's at. While he's doing that, he's on the phone, he picks up a BB gun that's out of the box, and he's looking at it, not paying attention, and walking through Walmart with it while he's on the phone. Some gentleman in the store calls the police and says, 911, this guy has an assault rifle, and he looks like he's gonna shoot somebody. The police come running in, and he's on the side walking with it on the phone, and before he realizes anything, he's shot dead. That's not a negligent security case, all right? But it's the same thing. The notice of the danger is how we argue for Walmart. You guys knew you were selling an item that looked like a real gun out of the package. You knew you were on notice that people were taking it out of the package. In fact, you had told the manufacturer to make it easier to take it out of the package. And it was foreseeable, getting back to these buzzwords, and you were on notice of the potential danger. And guess what? He's an invitee customer. You set in place a system of danger that ultimately ends up in his death. So that's an ordinary negligence case that had nothing to do with a negligent security, but it all comes back to notice, foreseeability, because what you have knowledge of creates the type of duty you have.
I
So
understand.
I'll let him talk about licensees.
Real quick on, and it's in one of these handouts, we keep referring to this statute, OCGA 5131. That number is actually really important. That's only for invitees. So every time we say that statute, we're talking about an invitee. And an invitee is someone that under the statute, where an owner by express or implied invitation induces or leads others to come upon his premises for any lawful purpose. So, like you go to the CVS, they're inviting customers to go there, the Walmart or other places. But it gets more complicated. So for example, a lawful purpose. If I invite somebody over to my house to engage in some drug use, is that inviting someone over for a lawful purpose? Probably not. But that's the standard we're talking about. Now, what happens if they're not an invitee? Well, the next statute, 5132, deals with licensees. And that statute says that the only liability you have is for willful or wanton injury. And that's a really high standard. That's basically like, I knew I was about to hurt you and I hurt you anyway. And then the next one after that would be trespassers. And you basically don't owe any duty to trespassers. It's very similar to that high standard. So that once you lose that invitee status, it's a really hard case. And in some of these cases, it's a fact question as to whether someone's an invitee or licensee. The point about if you're off lease, that can put you into a licensee status. And if you're in a licensee status, you owe this lesser duty. And so in a lot of these cases, there's a big fight over whether someone is an invitee or not.
So Eugene, are you asking your client, are you an invitee, licensee? What are you asking?
That's one of the first questions, and you said we filed a lawsuit. One of the things that I do, I want to eliminate that issue like within the first 30 days of litigation. And how do you do that? If it depends on who the person is, as he said, I ask a RFA, please admit that my client was a business invitee. And if I have a client who was on the lease, please admit that the lease that is attached here to as Exhibit A is a lease from your business. Yes. So now I don't want you to deny it, because a judge is not going to be kind to a person. If we have a lease, we attach it, and then you say don't have enough information to admit or deny when I've attached the lease to it. So that's one of the things I want to do right off. And when I'm doing depositions, I want to make sure that they admit that my client was on the lease or what have you. That's very, very important, because that determines what kind of duty that is owed.
Thank you. So Sean, we said filing the lawsuit. Are we filing it where the defendant resides, or are we filing it at the location place? Where are you filing the lawsuit? What venue are you picking?
You got to file on Georgia, where the defendant resides. And what you do on that is, a lot of times these property owners, if they're a big corporation or CVS or something, they're now moving up to what, probably Cobb County. Well, they can't even go to Cobb. Forsyth County. They're doing their registered agents there. That's why you also look at, is there a way to potentially add other individuals that can get you jurisdiction? Besides that, under Georgia law, you can file where the defendant resides. Other states, you file where the incident happened. So it depends on what state. But in Georgia, so we look at first where the owner of the property resides, and if it's not a good venue, we also look at if there's a management company.
I'm gonna pause you right there. When you say not a good venue, I know we got some trial lawyers in here. Shout out to the trial lawyers, but we got some law students. What's not a good venue? What does that mean to you?
It's changing, but typically a venue that is shown historically in data and past verdicts to give either less verdicts in the amounts, or to get defense verdicts, because just the citizens of that county don't appreciate the issues like other counties. So typically counties in the city of Atlanta, DeKalb, Clayton, Gwinnett, Fulton are better counties than if you're out like Forsyth, going past that Dalton area. It depends on where you're at. You want to be in more progressive, liberal places, and you want to be in places, typically, if you can find it, where people's per capita income is more. Because if you make more money, your mentality, if your house is worth $1 million, then if I ask you for $1 million for somebody's life, you're like, well, that ain't that much. So that's what I mean by.
Understand.
And then you also, a bad venue could be the judges too. Like, there's certain places that I don't want to deal with the judges either. So you you try to figure out in your theories where you're going on that, and so you can sue other people. One thing we've done, like we got it done in another case with apportionment, which I know we're going to get to.
I'm about to ask Naveen about that now. So
with apportionment, with the fact that the third party assailant is going to be on your verdict form, I go ahead and sue them. And the reason is they're going to be there anyway. And if they live in Clayton County, like the one we got, we just like, we'll go to Clayton County and we'll tell the jury, yeah, he's the assailant, he has some responsibility, but he doesn't have the opportunity to commit this crime but for the defendant. So give him 10% or whatever. Let's do 90% for the people who set this whole thing up.
Well, yes, Eugene, I'll come to you next.
There are essentially three things I look with regard to venue. Really four, but three. Number one, will the people who are on the jury like my client, identify with my client, be hostile to my client? That's number one. Number two, the facts of the case. You have alcohol and you're in some that's involved, your client at a bar or something. The actual facts, the story that I'm telling, is that something that just jury pool will be amenable to. 3, do they give money? You can have somebody who likes your client, somebody who likes the story, but as Sean says, not used to giving big money. And the 4th factor, less so, but very important, is what kind of court system do they have? Meaning, is it rural and they only meet once a year? And I get a trial this year. If I miss this trial, I got to wait a whole nother year. So those are the 4 factors that I look at.
I mean, they tossed around the word apportionment. Sure, yeah. So some lawyers don't know what apportionment is. Because can you just give us a brief?
Yeah, I'll try my best. It's very complicated. So there is a statute that was passed in 2005 as part of a tort reform initiative. Before that statute was passed, there was a doctrine called joint and several liability. And so if you sued one defendant, you could collect all of your damages from that one defendant, even if a bunch of other people were also at fault. And it was the job of the defendant to go get that money from those other people. In 2005, they changed that, and they basically said, well, if you sue more than one defendant, then that defendant can apportion the damages and fault to other people. So, for example, in the CBS case, there was CVS on the verdict form, and then there was literally a line that said shooter, because they never found the person who was the shooter. And so the jury had the ability to put a percentage of fault on the shooter, also on my client as well. And so that was what's called apportionment. And so sometimes the idea is, okay, well, let's just, if the criminal assailant is going to be on the verdict form, let's just sue that person already. We can use that to get a certain kind of venue, and we can also just be out in front of it. We've already named them as a defendant, and then we have this percentage of fault. It gets really complicated because there are more than one apportionment statute. So they amended that 2005 one to correct a problem, which was under the old statute, it only applied if you sued more than one defendant. If you just sued one defendant, there was still no apportionment. So there's this huge volume of cases that got filed before that new statute got passed and that are still being litigated. So you might hear various apportionment rules that don't always apply in the same way. And then there's another weird complication I'm just going to throw out there just for fun, which is in the CVS case, the jury said that the shooter was 0% at fault and that CVS was 95% at fault. And so I had the job of trying to explain how that could work.
I'm going to break. Any questions from the audience? Yes.
Gary, y'all done got to pre-suit, filing suit, and apportionment. Ain't nobody but Eugene talked about a damages profile for your case, except for he said he's going to mediation on Monday with $400,000 in damages.
Okay.
So, tell me, for these law students, young careers that are about to start, how y'all assess value and damages, especially if it's just a slip and fall and they ain't got $400,000 in damages, they ain't got a shooter, and they ain't got all the cases that you guys would be taking. Because if they get that kind of case, I'm assuming they're going to come talk to y'all. But if they do, you're going to help them. If they do not, and it's a small slip and fall case, how are you going to teach them how to assess the damages profile before you figure out whether or not you're going to file suit and deal with apportionment and spoliation and all the other stuff that goes along with it?
Say you, Eugene.
Well, one of the most critical elements of negligence is the last one, damages. What's the case worth? And we forgot something to mention that's very practical. And it's sort of unfortunate to see, and Sam mentioned about seeking redress from the civil justice system, something that people leave out, and they always attack lawyers as it relates to tort reform. And they leave out the fact that it is very expensive to pursue civil litigation. All of these cases that we're talking about cost at least $20,000, and easily every one of us have been a part of a case where we spent over $100,000, over $100,000. So I've actually had cases before when the lady comes in and tells me she had a slip and fall and they didn't have any signage up. She fell, and I said, and she said they admitted that it was their fault. And I said, well, what's your injury? She said, I went to the ER and I feel good now, and I got an ER bill. And she says, I said, what's your ER bill? She says, $2,000. And she says, do I have a case? I said, not really. And she wants to know why. I said, because your case is worth $5,000. And she says, well, I'll take that. I says, but it's gonna cost me $10,000 just to litigate it, and that's true, and to do a doctor's deposition and do all the things. So one of the things that we always wanna look at when we get the call in, what are their injuries? And different firms have different thresholds, but it must be of such a nature where it is, from a practical standpoint, as it relates to your tort book, it might meet all the criteria of duty, breach, cause harm. But if the damages are minimal, it's not going to be worth taking that case. And the reason why I say that is, all you're going to do is probably get a bar complaint and a pissed off client when you settle a case for $15,000 and you spent $8,000 and you haven't even been paid, and then they're talking about you got the money, the doctor got the money, and I can get anything. So those are real practical considerations that you must take into account.
Thank you. And then Sean, protective orders. We're seeing that more in cases now. What's your take on the protective orders in dealing with premises liability?
I hate them. I just think it's a delay tactic on discovery.
So what is a protective order, sir?
It's an order, I think in the context, I think this is what you mean. It's an order that's in place that you have the parties agree that before certain information is going to be produced, or is this the context you're talking about? Okay.
Yes.
Because people call them different things, confidentiality orders, protective orders, but they're typically, when you sue a property owner, they say, you know what, I got all these documents for you, but I'm not going to produce it because my corporate secrets and trades and how we do business is such a big deal. You have to sign off that you will never ever use this again. You won't share it with nobody but your expert. And really, they just don't want us talking among plaintiffs' lawyers and saying, okay, I know you sued Forest Code before. What did you get on them? And they kind of do all of that. I mean, it depends on the court and the systems. I don't really care how much I need to protect as long as I get the information and I can sue you, and I can move forward with litigation. Can I say this about the damage model, though?
Sure.
I was only following Gary's lead, so I didn't talk about damages, but damage model for a premise case is the same for a tractor-trailer case. It gets back to what I was like, the marriage of the client. You look at damages from the perspective of the story that you get to tell a jury. And your damage model should look at things like, what jurisdiction am I going to be in ultimately when I tell this story? Who am I telling this story to? Whether the damage is am I telling a story of thousands, 100,000s of medical bills? Or am I telling a story that even though the medical bills are not a lot, the pain this person deals with on a daily basis is so egregious? So your model kind of depends on what the case is, but I will say generally, premise liability cases are difficult because of all these other steps we've been talking about: notice, breach, CVS case, status, all these things. And we're going to get into experts and other things. And Eugene is right. I've spent from 20 to 150,000. So your ultimate model in a premise case is typically, I look at the injuries or the death and whether I believe it is going to be worth the money and resources. And if I can't do it, I tell you to refer somewhere else. Or I say, go call Eugene. He got a good heart. He'll take it.
Was there another question from the audience?
Well, actually, that kind of went to what I was going to, I was going to ask if you had a standard spiel, because I've had to, one of the hardest conversations I've had with just regular people when they say, oh my goodness, this happened to me, those outcomes range from damages that I think that won't be worth pursuing to, no, I wasn't hurt at all, but I could have been. I'm like, you don't have a claim. And I know that you're outraged, but that's like, how do you have a standard spiel?
It really depends on if I'm having a good or bad day.
Because they're heartbroken.
Yeah, and it's not their fault, because I always tell people, it's 100% pain, suffering to them because they live it. And we can get insensitive about it when I see case and case, and I've been doing this so long. So I have to catch myself. But at the end of the day, a $5,000 case to somebody is worth $1 million to them because that's happened to them. And you just got to appreciate and say, you have a claim potentially. You don't have a claim that I can help you with. And we have the Atlanta legal, we have referral places. I try to get relationships with lawyers who, it might not be a good case for me, but it could be a good case for them. The biggest thing, if you do take a case like that, communicate and be honest, and just say from the beginning, you may not get much money in this case. And I'm gonna see if we can do something with minimum amount of expense. But if it comes to a point that it can't be that way, you see this line in my contract where I'm gonna withdraw, I'm gonna do that. And I'm gonna tell you. And I've had cases where we found out and we got the money for them and we was like, we're not taking a fee out of this. Now I've gotten to a point in my life, because Gary and Sydney and Sam work hard, I can do that. But if you by yourself, you might have to just say, hey,
Yes, sir.
I need
Mr.
33%.
Just staying with Kevin's point.
Okay.
I know there are examples of cases like this that lawyers in here have handled, or Sean or Eugene have handled. Not all premises liability cases are wrongful death or catastrophic injury. I think Gary and I worked on a case with Ken that he can describe where
Yes, let's take a break.
medicals were not off the chart. Sean and I had a young kid who was shot in the hand. So I don't want you all to think it's all wrongful death, catastrophic injury, $100,000. There are a whole lot of cases that are viable. Can we talk about that?
Can I say this too? All of this is in the context of a post-COVID world, you guys. A case that we thought was worth $300,000 is a $3 million case now. I'm being real serious. So when you look at a case, you got to look at the story and who you telling that case to, because that's why Eugene said, where am I filing suit at? So in this case, we're talking about the medicals couldn't have been more than $20,000, $30,000. But I believe it's confidential. Our settlement was excess of $700 because we told a story that was going to be, how bad is this apartment complex? And if I get in front of this DeKalb County jury, I'm going to go piece by piece on the pain and suffering, that this $30,000 going to seem like the longest bill ever. So I don't want us to get it caught up in like, well, this is too small. Meet the client, see what's going on, see what your expenses are, and see what their bills are, and then figure out, can I do this? Or do I need to partner up with somebody? Because maybe it's a good case for two lawyers to get involved that limits the risk, limit the cost. But everybody should deserve to get a chance to get represented. And I don't want us to leave here thinking like, okay, if it ain't a death case or they're not paralyzed, I can't call nobody because they ain't gonna take it. That's not how you learn or that we should be providing justice.
So we know when we're following, yes, sir, I want to make sure I.
So how do y'all decide whether or not to take the case through billing or a contingency fee?
I only do contingency fee, particularly on premise cases because of the risk associated with. You're going to spend, even on a very small cases, you can go pretty quickly at, and considering the case that Sam and Ken and Gary had, that in big picture wasn't that long. But if you put the hours and time they did it, it wouldn't have been worth it to do it on a billable hour rate. So I would tell you to do it on a contingency rate and just kind of.
Ask one more question, then we're gonna move on. Yes, sir.
Hi, Tanner Fondren, 2L at John Marshall. The question I have for you, Sean, is what role do the damage reductions play in your damage model as far as like assessing damages up front?
When you mean damage reduction, what are you specifically meaning?
As far as like medical records, medical damages.
So I look at the medical bills before I file suit. I try to get all of that, see where I'm looking at, and then I say, okay, we got medical bills, but then I'm not just looking at numbers. What is that treatment? what's the long-term effects of the injury? Is this something they're gonna heal pretty quickly? I guess this was no, it wasn't a premise case. But I give you an example of a model, real quick. I had a case where a guy, foot got ran over, and all he had was a fractured ankle, okay? It healed without surgery, so my bills came to $6-7 grand. They disputed liability, and my damage model was really his pain and suffering. He was a young guy who healed pretty well and even ended up back at Lifetime Fitness. But I had the case. So when I argued closing, I said, okay, he's healed, but he has, and the doctor, I got him to testify to it, the doctor says he's gonna have arthritis, just general pain that associated as he gets older. And so I said to the jury he's gonna have this kind of arthritis pain for the rest of his life. Kind of like, but not constant. I don't want to overblow it. Sometimes he's gonna have a sting. I said, just like he having a cup of coffee every day. So I said, give him a cup of coffee. Give him Starbucks at $6. Give him a quick trip. But do this for the rest of his life. And he was like 22. By the time I did $5 a day, for all those days, we got a verdict for like $250,000.
So we're going to stop right there because I want to make sure we respect everyone's time. So we filed a complaint, we've gone through the discovery, and now it's time to hire experts. Naveen, you're probably getting parachuted into a case by now because that's when we decide we're going to need some help. Tell us about what you're looking for in an expert, or what you think a plaintiff's attorney would do in seeking out an expert.
Well, it depends on the type of case. So when we're talking about criminal act cases, a lot of times the experts are security experts. They're people who can testify about whether having an armed guard would have made a difference, whether having some kind of surveillance system would make a difference. And in the trip and fall cases, it would be an expert, sometimes an arborist, if it's a situation where you're talking about the effect on a sidewalk. So those vary, but all putting it all together, one is an expert actually needed? You really don't want an expert unless you need it. Sometimes you do need it.
Let me pause you right there. Yeah. How does some attorneys who's been practicing for 20 years may not know whether or not an expert is needed? So someone's coming out of practice 1 to 2 years, how are they going to know whether or not an expert is needed?
That's a good question. Reading the cases is really what I would like to say, is that it is one of those things that you got to read a lot of cases, you got to ask people who practice in the area a lot in order to know, because it really isn't that clear. And oftentimes, that is a conversation I'm often having with people, is somebody's asking me, do we need an expert?
Because don't everyone think that they just have to have an expert?
Right, and here's where I often end up saying it a lot in these premises liability cases is, unless you have the defendant themselves saying, yeah, if we had had a guard, it would have deterred this, I generally recommend that you get an expert in these criminal act shooting cases, because it's the easiest and most concise way to present to a jury and to a court that it would have made a difference. Because you know what I hear from most judges, sort of off the record about these premises cases, they say, why is the landowner responsible? If the police couldn't prevent this crime, why could the landowner? And what shuts them up usually the quickest is, well, there's a security expert who got up and testified and said, yeah, based on all of my research and experience, this would have made a difference. And they generally sort of say, okay, well, fine, that's for a jury. And so I don't really have a good answer as to like when it is, but I do know that it's really important.
So Eugene, you've gone through discovery. When are you getting your expert? When are you trying to determine whether or not you're going to get an expert on your file?
That's a good question. Typically, I'm thinking about an expert before I file suit, right? And he makes a good point. It depends on the facts. I will get an expert, but if I don't have to use them at trial and I feel comfortable that the facts and the evidence is overwhelming, that they knew about all these prior acts because their employees themselves were asking for security and they didn't have it, I'll get the expert to get me past summary judgment. And here's the thing about an expert. You want to get the expert before you file suit. But the key issue is when do you disclose your expert, right? You want to disclose your expert when you have gotten enough factual information by way of discovery depositions, by way of interrogatories that you can give them to your expert, because one of the things you have to realize is that once you disclose your expert, the defendants are immediately almost want to take your expert's deposition. And if you don't have enough factual support to have him testify, that could present some issues with regard to Daubert and other things like that. So I make sure that I've gotten enough factual information about the defendant to feed my expert, and then once I do that, I go ahead and disclose them.
Sean, when are you disclosing your expert? Are you getting your expert at the beginning of your case? What point are you getting your expert in your premises case? Negligent security.
Negligent security case, I try to get them as early as possible. Get them looking at the prior crimes that we've gotten through open records. Get them looking at any other information we have, so that I can have a good understanding. I got somebody who says this is a bad property. And it also helps me understand, okay, it's a bad property. The next important question is, what security measures should have been in place? And then the next important question that I think people stop is, well, if your expert says these measures should have been in place, fencing, surveillance cameras, security guards, the next question is, well, how would it have stopped this incident? Because you can have a guard and the person got shot in his apartment. And they ain't gonna stop the guard if he got shot by his friend.
Now, is that one expert or multiple experts?
Well, if it's a causation issue about whether security measure could have prevented the incident from happening, I think that's a security expert. If you're getting an expert that says this apartment complex or this business owner did not have adequate safety guards in place, and I am an apartment industry expert who talks about what industry standards are on liability or duty, that's a different expert.
I'll pause you there, Eugene.
And if you got a drug deal going back, you got some gang activity, you could have multiple experts dealing with certain issues, because ultimately what you're trying to say is your breach of your duty based on your notice, but for you not doing this, this thing would not have happened. And you need any expert that gets you from A to D.
And what's that gonna cost me, Eugene?
It depends. Anywhere from $7,000. And as you go on, it could go to 15, 20, 25.
For an expert?
Yeah.
I need to call yours. Mine's is like 25 to 30 just on the front.
Well, give me a call.
All right.
Yes, ma'am, we have a question right here, yes.
Yes, my name is Jody Ann Salters, 2L here at John Marshall. My question is, how do you decide, how do you choose this expert? Is it someone you usually go with?
I call Eugene.
And I call him.
No, real talk though.
Here we go, right here.
What happens is, this is a very small world and space. I know the defense experts. I could literally not have to take a defense expert in my cases now, because they use the same ones, and they could do the same with mine. We use the same ones. It's the same type of science. It's just how you want to come out on the other opinion. But this is the important part. They have to still meet the standards, the law, to get past summary judgment, to get past an appeal. So there are some guys out there who know what they're doing, but they don't meet the standards.
And we're gonna come to that, and I'm gonna give me 1 second. I wanna get this gentleman, and I'm gonna come to Naveen, because we're gonna ask him to clear some stuff up for us.
That hopefully, he got you.
Does the expert, like if you don't find any prior crimes, does the expert kind of fill that void if you can't find any? Like if it's a new place, like mom and pop, small spot?
It doesn't fill the void. The void for if you don't have crimes on the property is the CVS case. You go find crimes in an area and then try to connect the knowledge or the actual constructive knowledge of that to the defendant. That's not the void. The law, he did the void for us. What the expert does for you is give you a point for a judge to say, we have evidence that the standard required this. security measures. And if they had done that based on my expert opinions, I believe more likely than not, this would have deterred this incident from happening. And he better have, and I'm now gonna let him talk about it, he better have scientific methodology that says he can do this. He can't just be saying it because he went to night school somewhere, all right?
So Naveen, Eugene and Shean has hired this expert. Now you've parachuted into the case, they've hired you, you're reading his deposition, and you're deciding whether or not you're gonna do a couple of things. Shean's gonna hire you to protect his expert, correct?
Right.
And to Daubert the other side's expert. Tell him what Daubert is and what's the significance of that.
Sure. So Daubert refers to a United States Supreme Court opinion, which has now been codified in the Federal Rules of Evidence and in the Georgia Rules of Evidence. And so what we are trying to do to the other side's expert is say is that they don't meet the basic requirements. It's not scientific, that person's not qualified, and even if they were qualified and they had scientific methods, they didn't apply it reliably to the facts of this case. And then on the flip side, we're trying to defend against it. And a lot of this is a well-orchestrated dance. Shean is literally correct. He's not lying when he says that he doesn't need to take another Kareem Vellani deposition. He's already taken 50 of them. And so you don't need to do that. And likewise, our expert, Mr. Vellines, has been taken, his deposition has been taken by the defendant so many times it doesn't count. It presents a weird scenario, and I think Eugene mentioned this, where sometimes you have an expert that you use to get past summary judgment, but then you don't actually use a trial. So Mr. Vellines was the expert in the CBS case. When I read his testimony, I was like, this is perfect. These lawyers prepared him well, that's an important part of avoiding Daubert, is preparing your expert. And when I read it, I was like, I got everything I need. We're gonna win this appeal, and we did. But when I asked the trial lawyers about that, I was like, oh, he was horrible. He came off totally dry, academic. The jury fell asleep while his testimony was playing. And that's that weird sort of dynamic between, so there's a dynamic between what really happens in the world, and there's the dynamic what happens in trial, which is like a half of what really happens, and then there's the appeal, which is like a tenth of what actually happened at trial, even going further back. And so sometimes you have to do things that protect your record on appeal, like getting an expert to get past summary judgment, but that may have nothing to do with trial. And so one thing that whenever this conversation about experts and how you choose them and the fact that everyone's using the same ones, I get that. What I would love to see, and I don't know who wants to take the risk, is that we try some new people out and get some new voices, because the same old white guy that the jury has heard in a million cases surely can't be the best thing for our cases. And I don't know, I'm not the ones taking the risk, but it would be great if we got some other people in there.
So that's bringing us up to summary judgment. And one thing that I asked the panel to do is, a lot of times, and we hear about the $50 million cases, the $5 million cases, the $500,000 cases. I've asked them to just think about a case that they thought was a sure winner that they lost, and what did they take away from it? What they would have changed. So, Naveen, I'm gonna start out with you.
Yeah, so I would not say it was a sure winner. That was not my criteria. But there was a case that I handled with law firm Deitch and Rogers. It was against the city of Statesboro. It's called Gatto versus City of Statesboro. We went into it knowing that it was going to be a tricky case. And the really short story behind the case is that this young man was beaten to death at a bar right outside of Statesboro, right outside the college. And everybody in that city knew that they were serving underage, that there was tons and tons of violence. There was a whole FBI report and a mayor's report, and the big issue was sovereign immunity, whether the city was going to be immune. We lost the case on summary judgment on immunity. We lost it in the Court of Appeals. Then I got cert granted. I got the Supreme Court to say, oh, there's a really important question that we've got to take up. And I was like, okay, maybe we're actually going to get someone to agree with this. No, unanimously lost it in the in the Georgia Supreme Court. So not a single judge in the state of Georgia agreed with us on any of that. My co-counsel took, I think, 20 depositions. I think we incurred about $100,000 in expenses. We had 2 experts. And we had to tell, and we told the clients, these parents who lost an 18-year-old he was just a beautiful young man, that we got nothing for you. I don't regret it to this day. I'm glad we put the fight in, and all this talk about money and about taking cases. I was glad to have had a portfolio of cases so that in this case that I really still believe we were still right, not just right in terms of the law, but right in terms of justice, that I got to be able to do that. And you can only do that if you're playing the game of this business so that you get in these cases and you can put it. And I'm confident everybody, the rest of the panel has that as well.
Thank you, Naveen. Sean?
We're talking premise.
Just in general, so we can.
Real quick, a young man in Douglas High School, his teacher walks out of the door. We believe because she has a side business of real estate, and she's walking in and out doing side business while she's kind of trying to close a deal. While she's gone, the policies and procedures say you shall not leave your class unattended. It says shall. Horse playing around with his friends, something happened, he collapsed, and he is literally dying. They have to go to another teacher. By the time the teacher gets there, they get the police, this kid dies. We sued the city, we sued the teacher under immunity, under Georgia law, if it's a violation of a ministerial duty, a duty that you don't have the discretion, i.e. like a policy that says, thou shalt not leave the room. And our argument to the trial court judge in the Court of Appeals is, if shall is discretionary, please tell me I'm in the wrong English. And this was an English class, and I said, if it's shall in English, we in trouble if this is not ministerial. And the Court of Appeals disagreed. And the only other one I'll tell you, which is a premise case, a young man was shot and killed at Savannah State inside the student union when other students other people from Savannah who were not students got access to the campus because they don't stop people in guards. You can just ride on the campus. Come into that place, some people get into a fight, stray bullet, he's shot and killed at Savannah. You sue Savannah State. Savannah State is immune under Georgia law as a state university. So we found a catch-all. The student union was actually owned and operated by a for-profit separate company that the state of Georgia university system sets up because they sell bonds to finance all the stadiums you guys go to. So we said that ain't part of the state of Georgia, University of Georgia. And even the Court of Appeals says no.
And Eugene?
I had a case against Cato in Rockdale County. Young lady, African-American, with her children who were twins, go in on the 12th birthday. The daughter wanted, it was a young male and a female, and the young lady wanted to buy some, I forgot what they call it, those fake jewelry. And they go in, they decide they didn't like anything, and they walk back out of the store. And when they got into their car, the people inside called the police and said that they looked very suspicious. And the cops came immediately, made them get out of the car, made them sit there for about 45 minutes, and basically just accused them of various things and said that they were still in a search. And they was like, these kids didn't take anything. And then they went and looked at the video, and the video showed they didn't take anything, and the mother didn't take anything. Turns out that, and I was on my way, it was happening in October, I was on my way to homecoming, and my fraternity brother called me and said, you can't believe what just happened to my wife and 2 kids. So I ended up taking the case. We go past summary judgment, we go to trial. We try the case. They put the mother on the stand. I put the mother on the stand. She does very beautifully and direct. And then in cross-examination, she withstood that. And at the end, defense counsel asked, so you think my client was reckless and intentional and blah, 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 blah? And my client says, I don't know about that, but I know it wasn't right what they did. And so we go through the case. At the end of the case, we were having our jury, going over the jury instructions, and they made a directed verdict to get out punitive damages. And the judge says, your client on the stand says she didn't think it was reckless, so I'm taking that out of the case. Left in all the substantive claims. We won the case, but we didn't have a punitive damages case because something that we take for granted, it didn't go over complaint, it's my fault, that we should have said punitive damages. They ask you where it's intentional, you say yes because that's why we're here, and she didn't do that. The point I learned, go over the complaint and the claims before the deposition, before trial, make them aware of that. And that was a lawyer's fault. That was my fault.
Thank you. I want to thank everyone for their time. We're about to wrap up. Naveen, you're going to close us out. Summary judgment and appeal. So summary judgment, normally defense is going to file at the end of every case. Right before we get to trial, they're going to file summary judgment. How do you handle that, or what are you looking for in summary judgments?
Well, I think the toughest part about summary judgment from any lawyer perspective is you've got your entire case in your hands. I mean, most of the time when you get to summary judgment, you feel like, oh, I've done all of the work, I've gotten to this point, now I just need to sort of put a few things in front of the judge and then we get to go to trial. But you really have to take it seriously. You can lose your entire case, and you cannot rely on the fact that they're going to read everything. You've got to take your entire case and make it in a digestible format. So all the legal writing and all the emphasis on efficiency, you do all that work so that when you're in that moment, you know how to take this human complex story and put it in a brief that a judge will understand. And I know it's not a really technical answer to summary judgment, but it's really the answer that matters, which is that's exactly when you have to pull out all your analytical skills so that you can convey this important message. And then you get to trial, and then you can tell the full story.
Can I add one thing to that?
Sure.
If you're gonna call him, you should make sure as a trial lawyer you've asked the questions in discovery and depositions that you know are gonna be the buzzwords. The notice stuff, when you have a police report, you ask that department manager, isn't it true you knew about this incident? Isn't it true you told somebody else, because your job duty is to inform your superiors? You need to set the issue up and get evidence for the duty, the notice, the foreseeability, the causation. Because if you wait to do that and you get it to him, he's only dealing with the cards he dealt.
So Naveen, I know there's a lot of things, so we made it through trial, now we're at the appeal. Common mistakes that you see plaintiff attorneys, when you're trying to handle their appeal, what aren't we doing?
Well, I actually was going to piggyback on what was just said, which is that I really would recommend that anybody who goes into a personal injury case just pick one of the appellate opinions from that area and just look at the buzzwords. Like the eyes and ears buzzword is a perfect one for imputing notice from an employee. And every time I see that in a deposition from my co-counsel, I think they actually know what they're doing. And I can usually tell just from a deposition question how prepared a plaintiff's lawyer is, just because I see the ones that are and the ones that aren't. And the ones that are either gotten it through reading the appellate cases, or they've just read so many depositions.
When they got the ass whooped.
Well, that's it. Yeah, right. You lose one, and then you see what you have to do. But hopefully, the way you avoid some of that is by talking to people, looking at what they said in depositions. I mean, I spent a lot of time reading I've read almost everybody's trial transcripts, and you learn a lot from that. It's like watching game tape or something. And you do that early enough in your career, you've got it, stored in the bank of your memory, and you'll avoid those mistakes.
Thank you, guys. Let me tell the group this. You have this evaluating the agenda in front of you. Behind it is their contact information. And it's important for you to be able to know how to reach Eugene, Shean, and Naveen. They will definitely answer your questions. They're very, approachable. Now we're about to close out the seminar. I want to give out the shot to Mecca Anderson. She's in the audience today. She is running for judge of the DeKalb County State Court. So thank you for being in the audience. And to Sydney Marshall for helping me do this. Also, please look at your literature. It's a lot of information. Sam Starks, I want to make sure we give a handout, a clap to Sam Starks. He literally puts his blood, sweat, and tears into this program. And to get Naveen, Shean, and Eugene on the panel, that speaks, and with the lawyers in the audience from Tell me your name.
My name?
Yes.
Michael Dowd.
And he was on the case, or he's had,
Dyson Rogers, who I
Dyson
mentioned
Rogers,
on
yes. You got Ken Lanier in here, Torres Butterfield, Pete Brockton. So I just want to make sure it's a learning environment, and it's the practice of law. And as long as we all realize that you're going to make mistakes, you're going to have issues, and the biggest mistake that you make is not asking for help. And that's one of the things that Sam is trying to make sure the Barrister Society bridges that gap.
And that's an important part of what Sam is doing and what John Marshall does. I've been on a lot of these panels because I've been fortunate enough to get some good outcomes, and they usually need a black guy to mix in with all, and I get called. This is amazing that you got people of color on a panel. I've never sat on a panel that all of us, the next step, and it should already be happening, is we need women. We need every type of person and personality represented, because we all have something to offer. And that's what the barrister is about. And more importantly, that's what John Marshall's about. It's giving everybody a chance to be a part of this solution and provide justice to this country. And we're not going to get it until we all get together on this. So,
and the last thing from Torres Butterfield, Sam did a CLE, and he said one of the things that law students don't do is lawyers tell them, contact me, reach out to me, and you don't. So as you can see from Naveen, Shean, myself, anybody in here, reach out to us.